Good morning, everybody. May I have your attention, please? Welcome to the Constitutional Court. Court is about to start. Please make sure that the switch off your cell phone, please. Thank you. Good morning, everybody. May I have your attention, please? Welcome to the Constitutional.
May it please the court, I appear for the applicant, together with my learned friends Mr. Scott and Mr. Causa.
Thank you, Mr. Marcus.
Deputy Chief Justice, Justice of the Court, I appear on behalf of the 4th to 7th respondents.
Thank you, Mr. Dupier. Mr. Marcus.
Thank you, Deputy Chief Justice. We will address 3 topics. First, we will deal with the SCA's finding that the review was precluded by the res judicata principle. Second, we will show why SAFAM's activities fall within listed activity 8 and hence required appropriate authorization. And third, we will also show why listed activity 28 applied to SAFAM's activities and why those activities were unlawfully commenced without the required authorization. We stand by our heads and will not address other issues in those heads unless directed to do so. There is an application before the court for condonation for the lateness of the heads of argument. It's not opposed. Turning to the res judicata argument, where the parties to a judicial review settle their dispute and agree that a particular decision is reviewed and set aside, and a court so orders, this has the following 3 consequences. First, the decision in question is regarded as a nullity. It is as if it never existed. That is the way this court characterized it in NERSA versus the PG Group 2020, Volume 1, the South African Law Reports, page 450 at paragraph 87. Secondly, absent a direction by the court to the contrary, the matter is remitted to the decision maker for a fresh decision. That's what happened here. And third, once a fresh decision is taken, it too becomes the subject of judicial review, and that is also what happened here. Yet the SCA held that the review of the fresh decision was foreclosed because the settlement agreement had definitively determined all issues in that second review. We submit that was wrong both in fact and in law. The rationale underpinning the doctrine of res judicata is to prevent the same issues between the same parties from being re-litigated and the public interest in the finality of decisions. We, of course, do not quibble with that principle, but it simply has no application to the facts of this case for 4 reasons. First, as I've already alluded to, the decision which was the subject of the review was an entirely fresh decision. It had to be a fresh decision, having been set aside by the settlement order in express terms. There is nothing in the settlement order which relieves the department of its statutory and administrative law obligations when taking the fresh decision. And there is likewise nothing in the settlement order which purports to insulate the fresh decision to be taken in due course from judicial review. Secondly, at the level of fact, the information that served before the department for purposes of taking the second decision was not the same as that which served before the department for purposes of the first decision. And that is clear from the following facts. The settlement order itself contemplated that further information would be required for purposes of the new decision. SAFAM was directed in terms of paragraph 2.1 of the order to submit, quote, such further information as is required by the department. That was for purposes of ascertaining whether the land was bigger than 1 hectare for purposes of activity 28. Order 4 provided the first applicant shall submit the NEMA basic assessment report and the information referred to in paragraph 2.1 to the department within 5 days. In the affidavit by Mr. Matthews, who was the environmental officer responsible for dealing with SAFAM's application for authorization, he makes clear that there was additional information required, and he directed a request for that information to the independent environmental assessment practitioner. This was on the 15th of November 2019. You will find that in volume 8, page 708, paragraph 7, and his email requesting the additional information is on page 712. Mr. Matthews requested, for example, a detailed description of layout of alternative 2 and why it was not preferred. He wanted more detail under goal 1 of the operational EMPR regarding stormwater management and certain information about notification to interested and affected parties. On the 22nd of November 2019, that is after the grant of the settlement order, Eco Impact, that was the company which prepared SAFAM's environmental management documents, sent a submission to the department stating the department's email dated 15 November refers, please see below the information requested. You will see that in volume 15 at page 1266. The director's second decision of 29 November 2019 indicates that, among other things that were taken into account, there was a site visit on 11 November 2019 that is also after the settlement order. You will find that in volume 15 at page 1258. And the department itself makes clear its understanding that a fresh decision had been taken. You will see this in the letter written by the Western Cape Director of Litigation on 6 December 2019. That is in volume 15, page 1286, where in paragraph 8 of that letter he says, in any event, the department has now taken fresh decisions in respect of the waste management license application and application for environmental authorization, and has given the reasons for those decisions. And when the department informed SAFAM of its second decision, it also advised SAFAM to ensure that all registered, interested and affected parties be provided with the reasons for the decision and also be informed of their right of appeal. You will see that in volume 15 at page 1236, and this too underscores the fact that there was a fresh decision subject to a fresh appeal. And finally, in the answering affidavit in this court, the fact that a new decision was based on additional information is accepted. You'll see that in SAFAM's answering affidavit, volume 13, paragraph 6.2 at page 1104. So it was a fresh decision based on new information. The third reason is that it will be recalled that in SAFAM's review of the refusal of authorizations which led to the settlement agreement, one of the orders sought was a decision that SAFAM had, quote, not commenced with activity 28. You'll see that in SAFAM's notice of motion, volume 4, page 285 at paragraph 6, but the settlement order did not grant that relief, and accordingly, whether or not there had been compliance with listed activity 28 was an open question, and the settlement order did not touch on it. And fourthly, and as we have indicated in our heads and we submit decisively, the defense of res judicata was not pleaded at all. It has long been established, in fact going back 100 years, by the appellate division in Lowry versus Steedman, 1914, AD 532 at 539, that one cannot raise a defense of res judicata by way of exception. It is a special plea which is dependent on evidence and must be pleaded and proved. It is also, of course, a discretionary remedy, and a court must be possessed of all relevant facts to exercise the required discretion, and that did not occur because the matter was simply not pleaded. Now, our learned friend seeks to escape all of this by arguing that the settlement order was a judgment in rem and therefore binding on all. While that is a proper characterization of the nature of the settlement order, it simply doesn't advance the argument because it confuses the nature of the order on the one hand with the effect of the order on the other. What matters for present purposes is what the settlement order achieved. In simple terms, its effect was to set aside the decision, and it did so in express terms by holding that the decision is reviewed and set aside. But it did not, and we submit could not have, insulated any fresh or future decision from judicial review. Of course, the MEC and director were bound by that decision. It obliged them to take a fresh decision, and they did so. And it is that fresh decision which was the subject of a fresh review, and that fresh decision was based on new information that was not before the department when it took the first decision. Once the original decision was reviewed and set aside, thus requiring a fresh decision to be taken, the applicant's status as interested and affected parties did not change, and this is particularly so given the fact that their property bounded the project site. There is nothing in the settlement order which relieved the department from its statutory and administrative law obligations when taking that fresh decisions, and as interested and affected parties, the applicants had standing to challenge it. We don't understand our learned friend to suggest otherwise. So if we are correct that the SCA erred in its reliance on the res judicata principle, that clears the path for a consideration of the merits. We assume, for purposes of the merits argument, that this court will decide the appeal on the merits, but we recognize that the court may remit the matter to the SCA, and we wish to make two submissions in that regard. First, the SCA simply ignored this court's direction in cases like Spillhouse, that it is desirable for all issues to be decided. It didn't do that. So we are in a position not of our own making, but simply because the SCA did not do what this court required it to do. Secondly, the matter is squarely before this court, and this court has been presented with full argument, or will have been presented with full argument, and we would submit that it is in the interests of all parties that the matter be decided. Let me then turn to my second topic, which is listed activity 8, and the core question is whether SAFAM commenced that activity without the required authorization as required by Section 24F of NEMA. Let me start with Section 24F. The purpose behind 24F seems obvious. It is to ensure that potential adverse impacts on the environment are nipped in the bud before they occur. This is made explicit in Section 23(2)(c), which identifies the general objectives of integrated environmental management as including to, and I quote, ensure that the effects of activities on the environment receive adequate consideration before actions are undertaken in connection with them. It is also consistent with the principles set out in Section 2 of NEMA, which serve as guidelines by reference to which any organ of state must exercise any function when taking any decision in terms of the Act, and particularly Section 2, subsection 4A7, which demands a risk-averse and cautious approach. That risk-averse and cautious approach is the domestic embodiment of the precautionary principle. And as our courts have often recognized, this is an international standard. The cases which include this court's discussion in the fuel retailers case and Justice Rogers' judgment in WWF Africa versus the Minister of Agriculture all make this clear, but they are usefully collected in a recent SCA decision. I'll just give the reference. It's African Centre for Biodiversity versus the Minister of Agriculture, 2025, Volume 2, South African Law Reports, page 31, at paragraphs 11 to 19. That is the precautionary principle. Now, it is common cause that SAFAM applied for environmental authorization under NEMA to conduct listed activity 8, and in its application, under the section headed activities applied for, SAFAM identified both listed activities 8 and 28, and in relation to listed activity 8 as well as 28, SAFAM gave the description of the project as, and I quote, the development of a compost facility to recycle and treat abattoir and organic waste to produce compost on approximately 3.6 hectares. You'll see that in volume 3 at page 226. Now, the High Court correctly accepted as common cause that the development footprint covers an area of more than 2,000 square meters, and that the existing composting facility is not located in an industrial complex, and it also accepted that the process of converting abattoir waste into compost constitutes beneficiation. All of that is in the judgment in volume 11 at paragraph 92 on page 930. The sole question on the High Court's approach was whether the abattoir waste is or can be regarded as agricultural produce as contemplated in the EIA regulations. Now, respectfully, the High Court's reasoning is somewhat thin and focuses on the use by the applicants of the description of abattoir waste as a byproduct, and the court held that this was not sufficient to trigger listed activity 8. Of course, as we point out in our heads, the focal point of a review is to consider the reasons actually advanced by the decision maker and to determine their legality. That the High Court did not do. It found a fresh reason not advanced by the department. But leaving that aside, we submit that the High Court still got it wrong. The issue turns on whether the undertaking or activity involves the beneficiation of agricultural produce as used in the definition of agri-industrial. So to break it down, the position is this, leaving out unnecessary wording. Listed Activity 8 covers the development and related operation of agri-industrial facilities. I'm leaving out the rest. Agri-industrial is defined as an undertaking involving the beneficiation of agricultural produce. So if you read the two together, it would be the development and related operation of an undertaking involving the beneficiation of agricultural produce. We now have to fit in the definition of agriculture, which is defined as any cultivation or raising of crops, feeding, breeding, keeping, or raising of livestock. So if we read this into Listed Activity 8 together with the definition of agri-industrial and agriculture, then it would entail the following. The development and related operation of an undertaking involving the beneficiation of produce arising from the feeding, breeding, keeping, or raising of livestock. Now, it's clear on the facts that the feeding, breeding, keeping, or raising of livestock entailed the slaughter of that livestock with the inevitable production of offal, and that is explicitly pleaded in the founding affidavit in Volume 1, paragraph 100. It is essentially admitted in the answering affidavit in Volume 9 at paragraph 21, which refers to, and I quote, the byproducts generated during the normal operation of the abattoir. And in SAFAM's first review, which you'll find in Volume 4 at paragraph 31, pages 303 to 304, it is stated the abattoir generates animal waste. So it will be recalled that the whole impetus for the need to acquire environmental authorization was the decision by the Langeberg municipality to cease the removal of abattoir waste from December 2016. This was the catalyst for SAFAM to find its own solution to dispose of the abattoir waste, as it was put by SAFAM in its review, Volume 4, paragraph 33 following, at page 304 following. So the need for environmental authorization and the risks posed to the environment flowed from the unregulated or the potentially unregulated disposal of the abattoir waste. Now, Mr. Matthews, who was the case officer dealing with SAFAM's application for environmental authorization and who put up an affidavit, attaches to his affidavit a file summary, and he explains that this file summary includes, as he puts it, the notes made during the review process and reflected, and again I quote, all the material information to support decision making. Mr. Matthews' affidavit in this regard is in Volume 8, paragraphs 11 to 12 at page 709, and his file summary follows at pages 715 to 725. Now, Mr. Matthews' recommendation was that an environmental authorization be granted, but in the course of saying so, his own reasoning demonstrates why listed activity was applicable. So at page 725, his second bullet point, he says, composting the byproducts and organic waste diverts a problematic waste stream away from waste disposal facilities and allows SAFAM to use the compost on the land as well as commercially selling it to surrounding farmers. The site is located within an agricultural area where composting organic waste, albeit at a smaller scale, and application of compost to agricultural land is a common practice. And on the same page, in the paragraph numbered 15.3, that's page 725, he says, the option to recycle and treat abattoir byproducts, note it's Mr. Matthews who uses the word byproducts, and organic waste is beneficial for diverting a waste stream away from waste disposal facilities and providing an alternative disposal method for SAFAM in addition the final compost product can be commercially sold. And if you have a look at SAFAM's own description in its final basic assessment report, it explained in its executive summary, and you'll find this in volume 3 at page 215, in the bottom third of the page, it says that the facility, and I quote, will be capable of handling all organic general byproducts, again byproducts, pensmus, mainly water, and derms, blood, non-infectious condemned trim, and non-infectious whole carcasses from the Robertson abattoir and converting it to general use compost. And a few lines below that, that's still on page 215, SAFAM had explained that the wastes derived from the slaughter process are, quote, not waste products, since it is used as an ingredient to create compost. So, put differently, these are agricultural, or were agricultural, produce on any sensible interpretation of the term. So, we submit that the activities undoubtedly involved comfortably fell within the ambit of listed activity 8. That brings me then lastly to listed activity 28. Our learned friend for SAFAM contend that there is really only one relevant factual issue in dispute, and that concerns the size of the facility's footprint and whether or not it was less than 1 hectare. Their argument is that since the activities commenced on a site of less than 1 hectare, listed activity found no application. What we submit, and this is the crux of our argument, is that the facts show that when SAFAM began establishing its facility, it already knew and intended that it was going to establish a much larger facility in excess of 1 hectare, and that is what triggered listed activity 28. If one looks at the language of listed activity 28, it applies to commercial developments where such land is used for agriculture and where such development will occur outside an urban area where the land to be developed is bigger than 1 hectare. The language, in other words, is forward-looking. It refers to what will occur in relation to land which is to be developed. And so the core question we submit is whether SAFAM commenced its activities at a time when it knew that the project would be bigger than 1 hectare. The fact that it began its composting facilities before it had the requisite environmental authorization seems clear because SAFAM says as much. Let me give just the references, all of which establish that the activities commenced in February 2017. It's in the executive summary in the NEMA application. That's in volume 3 at page 215, lines 36 to 38. It's in an email from SAFAM's CEO to the Cape Winelands municipality. That is in volume 3 at page 217 at the top. In the department's explanatory affidavit, it is recorded, and that is in volume 8, page 681, paragraph 7.2. And in his affidavit in the first review, the CEO stated on oath that the disposal of waste from the facility commenced in February 2017. You will see that in volume 4, page 311 at paragraph 50. So, commencement is not in dispute. What is in dispute is the ultimate intended size of the footprint on which those activities admittedly commenced, and whether SAFAM's facility, which was presently less than 1 hectare, was part of a larger phased project and thus hit by listed activity 67. Listed activity 67 applies to activities where any phase of the activity was below a threshold, but where a combination of the phases including expansions or extensions, will exceed a specified threshold. Now, the evidence demonstrates in our submission beyond debate that from inception, it was anticipated that the project would be on land larger than 1 hectare. It was so described in the environmental application, volume 3 at page 226, which refers to the development of a compost facility to recycle and treat abattoir and organic waste to produce compost on approximately 3.6 hectares. The identical description size-wise is given for listed activity 8. On the 2nd of December 2016, the EAP submitted a notice of intention to submit an NEMA application. It gives the intended size of the project as 7.5 hectares. You will find that in volume 3, page 242, at paragraph 3.3. When the department, through Mr. Matthews, requested the EAP to give confirmation of the size of the existing composting facility and the applicability of the existing facility to listed activity 28, the answer given was the proposed application area, including the existing 1.7 hectares of the site for the compost facility, is 3.6 hectares. You will see that in volume 3 at page 270, and he attaches a plan which is at page 272, which indicates the area of 3.6 hectares. In the MEC's answering affidavit to SAFAM's review, it is recorded that the department had received the pre-application basic assessment report, which reflected that SAFAM proposes a development on 7.5 hectares. You will find that in volume 5, paragraph 50.2 at pages 403 to 404. It is also reflected in a letter from the department to SAFAM dated the 18th of April, which refers to 3.6 hectares. You'll find that in volume 3 at page 268, paragraph 2. It's again in the final basic assessment report. You'll find that in volume 7, page 599, under item 8.
Mr. Marcus,
Yes,
the gong has gone.
I understand. Obviously, I can take questions, but may I finish giving you the references? But I'm in the court's hands.
1 minute.
You will also find it in the application for the waste management license, which, although not in issue for purposes of this appeal, doesn't change the physical description of the project footprint. You will find that in volume 14 at page 1161, and under the heading detailed description, again 3.6 hectares, page 1162 at paragraph 34. But perhaps critically, it's the SAFAM's own attorney.
Mr. Marcus, you
Yes.
are finalizing your references.
Yes.
Shall we keep it there?
This is the last reference. If I may simply give it to you, SAFAM's own attorney gives the game away, because he writes a letter to the department dated the 16th of May. You'll find that letter in volume 3, beginning at page 275, and at page 276, this is now dealing with the very question of the size. He says, our instructions are that the size of the existing composting area is not 1.7 hectares in extent. It is also not 3.6 hectares, but much less. The reason why 3.6 hectares was originally mentioned in the BAR report by EXO Impact was that it represents the demarcated area earmarked where composting will take place in future, and only if a WML has been approved, and it goes on to that effect.
Thank
So-
you, Ms. Marcus.
Thank you.
Thank you very much.
Mr. Marcus, just briefly, can it be said that the SCA attempted to develop the common law as far as res judicata is concerned? And if there was such an attempt, was it properly done in terms of our jurisprudence?
Yes. We have made the argument in our heads, Justice Budget, that certainly a development was never pleaded. Certainly the SCA does not appear to be conscious of the fact that it was ostensibly developing the principles of res judicata. But it occurs to us that there's perhaps a different way of looking at the problem, and that flows from this court's judgment, I think, last week in Lewis Stores, in which the court was concerned of the wrong application of an established test. So on any of those bases, we would submit there is simply no call for the SCA to do what it did.
Lastly, as far as the remedy is concerned, if you're with you, remittal seems to me on the face of it to be the apt way to go here. I'll tell you why. If we were to decide whether this listed activities 8 and 28 do come into play, we will be engaging in quite complex factual inquiries. Was it commenced? Was it larger than 1 hectare? You've got to compare all the correspondence. So you've given us a whole list of references, and I'm sure perhaps Mr. De Beer will attempt to do the same, or will do so. So isn't it better as a court of last resort to have this matter remitted to the SCA for them to grapple with the merits? And then secondly, if so, I'm not saying you'll concede that, but if so, just hypothetically, should we be prescriptive about whether it should be the same panel or not? Is that something for the president of the SCA to decide?
Justice Majid, it's very difficult for me to argue against the proposition that you've put to me. I cannot do any better than repeat the submissions I've already made. From the perspective of those I represent, it's simply yet a further delay. But I certainly accept the complexities involved, and I have to say again with respect that those complexities were simply not grappled with by the High Court. So I can't argue against that other than the two propositions which I've already advanced. Whether it should be a different panel. Justice Majid, I know that that was the course taken by this court, for example, in McCarthy. I don't suggest...
That's a completely different...
Yes, I was about to say, I don't suggest that this is a McCarthy-type situation. I suppose purely from the perspective of perceptions, it might be helpful if that were so directed, but I can't say that as a matter of principle that it should be.
Thank you. Thank you, DCJ. Thank you, Mr. Marcus.
Thank you, Mr. Marcus. I have just two questions, one on res judicata. The SCA said the applicant could have sought an application for rescission.
Yes.
How is that, how would that have happened where the applicant was not a party to the settlement agreement?
Well, again, Justice Mshantla, the greatest of respect, it's very difficult to understand because it goes absolutely contrary to the then Appellate Division's own decision in the Amalgamated Engineering Workers case. And we cite that particular passage in our heads of argument, which makes it clear that the principle of res judicata cannot apply to a party who was not before the court. And we know that Amalgamated Engineering Workers is good law. It's been followed many times by this court. Respectfully, I cannot give a sensible answer to what the SCA had in mind in that finding.
Now, assuming we get to the merits, I just want to find out, just to establish, your understanding or to help me understand your argument insofar as listed activity number 28. I think that's the one that talks of one must not exceed 1 hectare. Applicant's argument is that because the respondent had already indicated an intention to end up developing more than 1 hectare, that they should have applied for the license. Is that what you are saying?
It's quite clear that the respondent's argument is that the existing facility is less than 1 hectare, therefore listed activity 28 is not triggered.
Yes.
Our counter to that is that that goes quite contrary to the development of the historical development of the statutory scheme, particularly in regard to the nature of the words commence, particularly if one has regard to the purposes of the need for prior authorization, and in circumstances where the intention from the outset was to create a facility which would be above the 1 hectare threshold. What the environmental literature refers to is the rather colorful phrase of salami slicing. And there is a different and perfectly good existing legal framework within which to accommodate that concept. It could be, for example, accommodated under the rubric of the old common law idea of acting with an ulterior purpose, Van Eck and Van Rensburg versus Etna Stores. That, the SCA says is now accommodated under the principle of legality. But there is another, perhaps better way, and it's a question of never elevating form above substance. And it goes back to, and I accept in a very different context, Justice Schreiner's famous dissent in Collins's case, Collins versus the Minister of the Interior, where the question was, can you disaggregate the various steps that were taken to disenfranchise coloured voters? And Justice Schreiner said, you can't. The character of a decision is taken from the whole, not each individual part. If I could give you the reference, it's 1957, volume 1 of the South African Law Reports, page 552, Appellate Division, and it's Justice Schreiner's dissent at page 574. And it really captures it, if I may simply just read the paragraph. He says, the reasoning is that so long as the legislation required to remove the coloured voters from the common voters' roll or to modify or repeal the language guarantee can be split up into stages, each of which taken by itself is legal, the whole is legal, even though the 2 or more acts required constitute a legislative plan to create a 2/3 majority by introducing into the legislature persons nominated for the sole purpose of securing that majority. There appears to be no authority for the proposition that such piecemeal progression avoids invalidity, and it seems contrary to principle. In general, the parts of a scheme take their character from the whole. And it's taken a long time, but that dissent did finally attract approval from the SCA in 1999 in a church dispute near the Duitse Gereformeerde Kerk. It's 1999, volume 2 of the South African Law Reports, page 156 at 170. So there are different ways. Salami slicing does capture the underlying concept, but it is well accommodated under very accepted legal principles.
Now, NEMA, that is section 24, does it speak to future intended development? Because my concern is if one meets the threshold and the development is below that 1 hectare, why is that person expected to apply if at a later stage, that person may decide to do something else that will exceed one hectare.
Yes.
There's something in the act that specifically says, if that is so, you must apply from the onset.
It's listed activity 67, which deals with phased activities. And it deals specifically with a situation where the ultimate product, for want of a better description, will exceed a particular threshold. That will be my first answer. My second answer is that NEMA as a whole, as a statute, is aimed at prevention before disasters occur. It recognizes that there are situations in which once disasters have occurred, environmental disasters, they must be managed. But in circumstances, the entire system of prior authorization is to prevent harm to the environment. There are certain activities which are listed, which require that prior authorization, and the ultimate purpose must be to ensure that the harm doesn't occur, or if it is inevitable, can't be avoided, that it is mitigated. So where one is concerned in relation to listed activity 28, with something that everybody knows from the beginning is going to exceed that threshold, then we submit listed activity 28 is squarely engaged.
Thank you. Thank you, Mr. Chair.
Mr. Marcus, one of the problems here, or the issues that arise, is whether you should not have been joined or you should have been joined.
Yes.
And then it answers the res judicata point. What I want to know from you, because I'm not sure at the moment, is whether it is necessary for us in this matter to then deal with the issue of joinder, whether you should have been joined or not. And we look at APSA versus Nodie, and then what do we then decide from there? The reason I'm asking this question and why it bothers me is because there are many review applications against state entities. And I ask myself this question: is it necessary in all those review applications for the person, for the applicant to look at who were all the parties that are interested, and so that they are joined in that matter?
Justice Cheeky, I can't give a one-size-fits-all approach because I'm alive to the fact that this does frequently happen, and I'm not advancing an absolutist approach which says that in every such application all the parties have to be joined. But this is a particular case where the applicant, my clients, were registered, interested and affected parties. They made representations against the grant of authorization. In this particular case, we would respectfully submit there is little doubt that they should have been joined. In relation, however, to the, I think, somewhat narrower question which you are putting to me, and that is whether you have to decide, in this case, the joinder issue. My answer is you don't have to decide the joinder issue. If you are satisfied that the SCA simply got the res judicata principle wrong on the established test, it's neither the same parties, nor is it the same facts. So you don't have to go there, but in relation to this case, I would most undoubtedly submit that we ought to have been joined in that review.
Okay, thank you, Mr. Marcus.
Thank you, Mr. Marcus. Just one question from my side. In response to my brother Justice Majid's questions around remittal,
Yes.
you seem to take the view that you can't really put up a strong resistance against remittal for the reasons that you engaged in with regard to the complexity of the matter, etc. But I wonder if you'd have a view on another reason, and that goes to what may be regarded as a fair and constitutional division of labor between courts. It's really a policy question that often this court, sometimes for convenience and because it's practical, deals with the matter. But ultimately, it may do so, and in doing so, it effects an unfair division of labor. And it labors this court with matters that it should not. And it's just not a question of its workload, but it's a question that courts should discharge what is properly their responsibility. And
Yes.
your view on that?
Justice Colopin, I can do little better than go back to what this court said in Spillhouse and in other cases. And that was designed to meet the very problem that you identify, the proper division and allocation of labor between the courts in the hierarchy. If the SCA had done what it should have done and decided all issues, we wouldn't be having this discussion. And that's the dilemma which this court faces, is that you simply are now not in possession of a reasoned judgment on the core issue from the SCA. Outside of repeating the admonishment in Spillhouse, but perhaps in stronger terms, I'm not sure what I can suggest. It's an inconvenience, I can't put it higher than that, to those that I represent, and I would suspect the same is equally true of those whom my learned friend represents, and I see that he's nodding in agreement. So we are both, in a sense, the victims of that shortcoming, and I would simply suggest a reiteration, but perhaps in stronger terms, and explaining it in the way that you have done would be in order.
But even though you'll continue to be the victims of that shortcoming with remittal?
Yeah.
I suppose it is what it is.
I can't persuade this court that you are in possession of a reasoned judgment from a lower court in relation to matters of some complexity on a record that's, I don't know how many, but it's well over 1,000 pages. I think it's probably about 1,500.
Mr. Marcus, assuming we do decide the merits of the case, and assuming we reach them, given the raised judicata point, first of all, in regard to activity 28 and the idea of phases, is there a difference between a situation where a first phase is merely a step in something in a larger development without which the first phase on its own would not be viable? In other words, subsequent phases are critical to whether the person undertakes the first phase at all. Contrast that with the case where a person says, and I put this hypothetically for the moment, I'm content, I will, and I do intend to conduct a composting facility on not more than 1 hectare. But if I can get the authorization, I wish to do it on a larger scale. But the larger scale is not necessary to make my current composting facility self-standing, and I will do it. If even that situation, you say, falls foul of the salami slicing prohibition, it really means that a person who genuinely wants to do something that is lawful and is content to limit it to that if they don't get an authorization can't do it until the authorization for the larger thing has either been refused or granted. That doesn't seem to me, that doesn't make a lot of sense to me.
I would accept that proposition, Justice Rogers, but I would counter it by saying it simply doesn't find application in this case. In this case, what you have seen is literally from the outset the clearest of intentions to create the larger facility. And the explanation given by SAFAM's own attorney puts that really beyond debate. So it's...
I recall that passage you read, I don't have it in front of me, said, and it will be 3.6 if we get the environmental environmental authorization. That doesn't, is there anything that indicates that they don't want 1 hectare if they can't get 3.6?
I will have to check that. I think not, but I don't want to give a reply from shooting from there.
But on the point of principle then,
Yes.
you would accept that salami slicing can't prohibit what we can call phase one if the person is willing to do that on its own as a self-standing development if they're not allowed to do more.
I would accept that.
And then in regard to activity 8, am I correct that SAFAM receives animals for slaughter? It doesn't itself rear animals.
The entire undertaking, as I understand it, is to create an abattoir facility. And that was the impetus behind the whole project.
Yes, but it's not raising its own animals and then slaughtering them. It's receiving animals for slaughter.
As I understand it, that is the position, yes.
Now, is slaughtering an animal that is reared by a farmer, is that itself agriculture? In other words, do you need, and did SAFAM need an authorization for activity 8 to conduct the abattoir?
Well, probably yes, because activity 8 concerns, amongst other things, the raising of crops, concerns feeding, breeding, keeping, or raising of livestock. Now, that's very broad terms.
Yes, I can understand that if the farmer herself rears an animal and then slaughters it, that's all part of agriculture. But if a person's only activity is to slaughter, that doesn't seem to fall within the ordinary meaning of breeding, keeping, raising.
In this particular case, slaughter was intended from the outset. That's what this case is about.
Just assuming for the moment that, as I understand it, up to now it hasn't been said that, because SAFAM has been conducting an abattoir for some years, previously the waste being collected by the municipality.
Correct.
So up to now I don't understand it to have been contended that it needed an authorization for activity 8 merely to conduct the abattoir.
Correct.
That then must mean that killing the animal was not regarded as agri-industrial activity. So what one would then need to say, but if bits are left over that aren't sold as meat and they are beneficiated, then that, that waste material is, it has to be what the beneficiation of agricultural produce.
Correct.
Now, is the waste itself produce? Does it matter that SAFAM itself doesn't carry on an agricultural activity? You say it doesn't matter because what it is doing is the waste material is itself produce, albeit from somebody else's agricultural activity.
Correct.
And all that they need to do in order to bring themselves within the scope of 8 is to beneficiate that. So for example, a milling company that receives wheat from farmers and mills it into flour, would that be the beneficiation of agricultural produce?
It would certainly be beneficiation, no doubt.
And that would then apply to taking advantage of any byproducts, even if they aren't the primary object of the beneficiation.
Correct.
Yes, thank you.
Thank you.
Go ahead, yeah.
I have a bit of a difficulty with the definition of commence in the Act and reconciling it with your submission regarding of the start of the intention, because the definition says commence means the start of any physical implementation in furtherance, and then it goes on.
Yes.
It sort of suggests to me that there has to be some physical or overt undertaking in furtherance of the intended project. I'm not sure how that works out in relation to obtaining the required permission, so to speak. And I wonder if you can help me as to how does it unfold practically? What does physical implementation mean in the definition? And how does that reconcile with your submission on comments in this case?
The argument we advance, Justice Dambuza, is entirely compatible with the definition of commence. One has to go back to section 24F, because that's where the prohibition, for want of a better description, begins. It's that you may not commence any activity. Notwithstanding any other act, no person may commence an activity listed or specified. So,
unless the competent authority.
yes. So the philosophy underlying it is the one that I suggested at the outset. It's that certain activities are listed because they have been identified in advance as activities which potentially adversely affect the environment. So if you want to do one of those listed activities, like I'm not using the language, conduct an abattoir, you're not allowed to start it without the required authorization. There is a mechanism in the Act which caters for the situation where the activity has started without the required authorization, and there is a process by which you can get retrospective authorization.
But generally, what do you mean when you say start? You're not allowed to start.
I agree with the suggestion that you've put to me. It does envisage some sort of physical activity.
Well, that's what the definition says in terms.
Yes.
That it is the start of a physical implementation.
Yes.
I really don't know how it really, in effect, takes place, because a person intending to undertake an activity would have to apply full time. But if the Act requires that you do so when you commence, and commencement means the start of physical implementation, the words used seem to be quite deliberate and in reference to the physical implementation.
It would require some overt act, and I can certainly see that in particular situations it might be a question of degree.
So in this instance, you referred us to all those references. Where do we go to determine whether some overt or physical implementation had actually taken place?
Justice Dambuza, the record is replete with evidence of the fact that windrows had been conducted in which the waste byproducts had been placed for composting activities. I will try and find you a list of those references for purposes of the reply.
Well, doesn't that relate to the smaller than 3.6 or 7 hectares?
Yes, it does, but the short answer to your question is, was there a commencement? The answer is yes. The real question before the court is whether that commencement was lawful.
Well, my difficulty is whether the commencement is the commencement in a smaller portion.
Correct.
Is commencement in the sense envisaged in the definition.
It is envisaged in the definition. If my argument were to be rejected, and that listed activity 28 was not triggered because it did not exceed 1 hectare, then the fact that they had commenced is neither here nor there, because they were legally entitled to commence because authorization wasn't required. If, however, my argument is accepted in relation to what was always envisaged and intended from the outset, then that commencement would have been unlawful.
So a person intending to start may not say, all right, I will start with less than a hectare, and therefore I'm not, at least at this stage, required to seek, what's wrong with that, to seek authorization. Why is that not compatible?
Well, because where the ultimate intention is for a larger project above the threshold, the whole process of environmental impact assessment has to consider the impact of what will occur when that expansion actually takes place. In other words, the very foundations for the grant of authorization are different, because you are looking at a much wider project, and by definition you are looking at a much wider potential adverse impact on the environment. And that is one of the mischiefs which is sought to be prevented by avoiding this sort of piecemeal approach to obtaining authorization.
My difficulty is that the ultimate intention argument seems not compatible with what the Act says.
Respectfully, it is, because if you accept my argument on ultimate intention and you read it with the definition of commence, it would mean the start of any physical implementation in furtherance of a listed activity. The listed activity in this case would be constructing an abattoir on an area greater than 1 hectare. It goes back to the device, as we put it, and we submit it simply is a device to evade the real intent of the law, of doing it in parts so as to escape the need to obtain prior authorization.
Okay, I hear you. Thank you.
Thank you.
Thank you, Mr. Marcus. Hello, good morning. I just wanted to raise with you the issue of listed activity 67. It doesn't appear anywhere in your papers. A reliance was placed on 67. And one wonders whether the salami slicing argument and the phases can in fact be explored, given that the issue hasn't been previously argued. In fact, reliance wasn't placed on it earlier.
The salami slicing approach was most specifically pleaded, albeit without mention of 67. You'll find that in the founding affidavit in Volume 1 at paragraph 134 at page 54. It's set out in a long paragraph and following, but it is unquestionably pleaded.
But reliance does seem to have been placed by the applicant throughout on listed activity 28.
Without question, yes.
And are you saying then that we must read in reliance on 67 if we're to reach the issue of the
Correct.
phases? That's, of course, if we get to determining the merits.
Of course.
Thank you.
Thank you, Mr. Marcus.
Thank you, Deputy Chief Justice.
Here.
Deputy Chief Justice, Justice of the Court, Mr. Marcus and I are both new to this matter, and I'll say later, I don't want the matter to go back to the SCA as much as I would like to go argue it twice, and maybe a third time here. But what I want to start with is the real substantive issues here. People in South Africa eat meat. And in order that people can eat meat, we need to have abattoirs. And it's a fact of life that abattoirs produce waste. And the question is, something has to happen with that waste. And what the facts of this case demonstrate is that my client's facility is the best possible practical outcome for the environment to address that waste. Take the court to the pages in the record in due course. But I don't want us to lose sight of the fact that this is an environmental case about inevitable waste coming from an abattoir, which we have because people eat meat. And the question is, what do we do with it that's best for the environment? Why we're here is because a private game reserve owner, whose house is 3 kilometers away, he doesn't like the fact that there's a facility next door. And he claims that more flies came about on his game farm after the facility was set up, and that there were foul odors. Of course, there's no evidence to demonstrate this, but that's what's claimed in the founding affidavit. Ultimately here, neither Section 24 of the Constitution or NEMA give him a right to halt the facility. All he can do is try to say that my client should have gotten a prior approval and have an argument about that. The MEC on an appeal and the High Court overwhelmingly rejected the applicant's arguments. And I will show the court why they were right to do so. There's a bit of a sideshow, which is what the SCA did. I'm going to assume for purposes of my address that everything Mr. Marcus said about the SCA is correct, that the SCA was wrong. I will assist the court with questions, but I'm not going to take up my time on the res judicata issue. Where I differ from Mr. Marcus on the question of whether there's a reasoned judgment here is that there is one. It's the judgment of Justice Nuku in the High Court. It's 162 paragraphs long, it's 85 pages. Of course, there were a lot of other issues which have been abandoned. But I don't think it's fair to characterize that judgment as not being well-reasoned. We know this court on many occasions has dealt with matters directly from the High Court on the merits. When I was a clerk here, about a decade ago, there was a case of Loebscher. I don't have the citation. But that matter came straight to this court and frog-jumped the SCA. So my submission would be that it would be appropriate for the court to deal with the matter on the merits, because really the applicant is bad on the merits, and this matter needs some finality. I've got 6 topics that I'm going to get straight into. So the first is just to situate us within the constitutional framework. Section 24 of the Constitution, of course, says that we have a right to a healthy environment. We have a right to an environment protected for the benefit of present and future generations. We also have a right to secure ecologically sustainable development and the use of natural resources while promoting justiciable economic and social development. What this court says in Fuel Retailers, it's paragraphs 44 and 45, is that the right to the environment is important, and so is the necessity of having development so we can achieve socioeconomic rights. And there has to be an integrated process of dealing with them. In paragraph 61 of Fuel Retailers, the court describes NEMA as requiring the integration of environmental protection and economic and social development. Whenever a development which may have a significant impact on the environment is planned, NEMA envisages that they will need to weigh considerations of development as underpinned by the right to socioeconomic development. Section 2(4)(b), one of the principles my learned friend referred to in NEMA, requires decision makers to consider the best practicable environmental option. That is a guiding principle in understanding NEMA and the listing notices under it. And I'm going to return to that issue in due course. Under NEMA, let me start again. So what the Constitution envisages is a balance. We protect the environment, but we don't stop development outright. And we know why that's important, because we need a developmental state in order to provide basic goods. And the good in issue here is, of course, access to food, which is a constitutional right in Section 26. What Parliament does in enacting NEMA is it says not all activities that might impact the environment will require prior authorization. What it does in Section 24 is delegate a power to the minister. It says, Minister, you need to identify activities. that require prior authorization. And the minister exercises that power, subordinate legislative power, and strikes a balance between protecting the environment and facilitating socio-economic development. And much of the listed activities have thresholds in them. Up to a hectare, you don't need prior approval. More than a hectare, you do. Or your road, if it's under 1 kilometer, you can build it without prior approval. After that, you do. And I agree with Mr. Marcus, this is a policy decision taken by the state through the minister now, saying there are some activities that we don't want you to start until we've checked it out and made sure everything's all right. Section 24F is a criminalizing provision. It says that if you start a listed activity without prior approval, you commit a crime. And that, of course, has implications for how we interpret them. We can't interpret a vague listed activity of criminalizing some conduct, for example. Critically in this case, the applicant he's never challenged the listed activities. He's never said listed activity 28 is a problem because it allows up to 1 hectare. Or listed activity 8 is a problem because composting falls outside the definition of agriculture. So the court must work with the language in the listing activities. Of course, it's an interpretation question. That's my first topic. The second topic is just to talk about the facility. Now, the municipality used to take the waste, and as I understand it, put it in a landfill. And in 2016, it said no more, because there was a draft norm for organic waste. It's explained in the MEC's explanatory affidavit. It's volume 8, page 688, paragraph 38. And what the national government's draft policy said at the time was, get organic matter out of dumps. And that's for good reason, because we can compost it, and that's a better environmental option. And my client, SAFM, says in its answering affidavit, it's 2 places in volume 9, page 730 and page 799, paras 10 and 112, that they had to make a decision of where to take the waste. It had to go somewhere. And this is eventually what they considered and investigated and found. Another point is that the facility is well run. So again, to the flies and foul odors, the MEC in his decision, it's volume 7, page 597, records that various officials have gone to inspect the facility and found that there aren't too many flies or odors emanating from it because it's well run. In the answering affidavit, it's volume 9, page 737, paragraph 22.2, there's a reference to a provincial vet, Dr. Leesk, that says basically that the facility is so well run, we want to make it an exemplar. So we're not dealing here with some fly-by-night issue where the organic waste is being dumped and left alone. It's being run properly. The MEC in the explanatory affidavit says, volume 8, page 698, paragraph 67, that this is the best practicable environmental option. And that's all what NEMA is about at the end of the day. And then the last question about the facility is how far away it is from the applicant's house. As I understand it, the applicant, there were 2 applicants, Mr. Justus passed away, Mr. Jordaan is still here. I understand that his residence is 3.7 kilometers away. It's in the answering affidavit, page 734, paragraph 18. And I did a little Google map exercise, which is dangerous because Google Maps is not accurate. It's part of this record. But from here, on Google Maps, 3 kilometers from the court is the other side of Zoo Lake, the other side of Wits, the other side of the M2, and just about to Bezuidenhout Valley, going that way. So we're not speaking about adjacent properties in an urban setting here. Now, my third topic is listed activity 28. And before I start, I want to stress to the court that you shouldn't remit the matter. And the reason why is because we've come a long way. There is a reasoned judgment by the High Court on these issues. The court might disagree with it, but it's there to assist the court. And the court does have full submissions on it. The heads of argument are detailed. The oral argument from my learned senior and myself here hopefully will assist the court. It might be that the court admonishes the SCA for what it did in the judgment and say, well, you should have decided all the issues. And Spillhouse, and I think it's S versus Jordaan, was one of the first judgments that said this, applies to any court other than the Constitutional Court, including the SCA. But I would say in a matter like this, for us to go all the way back to Bloemfontein and then perhaps come back here wouldn't be in the interest of justice, in the interest of finality. So the essence of illicit activity 28 is this. Does it allow a party to commence with an activity up to 1 hectare while intending in future to extend that beyond 1 hectare? I think Mr. Marcus and I agree on that. That's the issue, the crux. If no, then Mr. Marcus must win. But if yes, then my client must win. I'm not going to take the court to the size of the facility because I don't believe that was argued. The facility is less than 1 hectare. It's in the heads of argument. There was a surveyor who went to look at it. So I'm just going to skip right over that and go straight to intention. What's important to understand is that in NEMA and the listed activities, the minister has prescribed different sorts of activities. Some that have thresholds and some that don't. So if you're below a threshold, development may happen without pre-authorization. The length of a pipe or road, the size of a facility. But others require pre-authorization outright. So nuclear facilities, in my head's paragraph 58, I gave the court the relevant reference to, I think it's listing notice 2. Obviously that, you can't say a nuclear power station that's producing less than 10 megawatts doesn't require prior approval. And the reason is simple. That sort of environmental harm is much greater than general impact on the environment by activities. So just to take organic composting generally, it's a bit silly, but in my house, I have a little composter. And what I tried to put in there, if I really have the time, is our trimmings from our kitchen and our grass and the leaves that come off the trees. Of course, I don't need prior approval for that. There is an impact on the environment because I use it in my garden. That's a bit silly. But what about a local nursery? So down the road from my house is a nursery with a playground, and my son likes exploring, including where they do the composting. I can't say how big it is, but it's certainly a lot bigger than what I have at home. Does that require prior approval? No. The point is that there's a line drawing exercise on these threshold activities. And the minister in this case has drawn a line at 1 hectare. And that's a policy choice taken by the minister. And again, a policy choice which has not been challenged by the applicant. So moving to intention. The argument is that if your intention is ultimately to have a bigger facility, then up front, before you start, you have to have applied, even though you haven't reached the threshold yet on that activity. The first problem with this is that the definition of commencement doesn't speak about intention. It speaks about the starting of physical implementation in furtherance of a listed activity. So one can't get around the fact that you have to look at what's provided for in the listed activity. And if there's a threshold provided for in it, that sort of brings you to the end of the road. Unless you challenge that and say that the threshold is a problem. I was thinking of an analogy that can maybe explain it a bit differently. I was thinking about building. Let's say I've just bought property as a junior advocate, and I want to one day build a 2-story house. But because I'm only a junior advocate, I can only afford to build 1 story. And let's say under my local municipality zoning scheme, I can build 1 story without permission, but I need permission for 2 stories. It does seem a bit strange to say, Mr. De Beer, you can't build the 1 story in the meantime, even though you're far away from becoming a silk and will have enough money to build the 2nd story. You have to have applied for both stories up front. Because that's effectively what the argument is. The argument is, if you might intend doing something one day that's above the threshold, you have to have applied up front. Now, I'm not going to run away from the fact that my client says, yes, I'm applying for an environmental authorization up to 3.6 hectares. There's no intention of evading that obligation or requirement here. That's what my client does. But what my client says is that if we don't get the environmental authorization, then we will have to stop at 1 hectare. And of course they will. 28 would preclude them from the prior authorization. My learned senior referenced, spoke about not elevating form over substance, and we heard a lot about the Collins case and the good Schreiner dissent there. And I agree that one mustn't elevate form over substance. What's important here is that, and why that's not analogous at all in my submission, is that in that case there was a clear intention to avoid the 2/3 requirement for amending the Constitution at the time. Here, my client has no intention of avoiding any responsibility or obligation to apply for and obtain an environmental authorization. That's what they did. They just said, unless and until I get that, I'm permitted to create or build the facility up to 1 hectare, and that's what I'm doing. So yes, don't elevate form over substance, but my argument certainly doesn't do that here. On salami slicing, just briefly, the problem there, and this comes from the article that my opponents had cited, the problem is there, it's usually associated with an attempt of a developer to avoid environmental impact assessments or facilitating the approval. That's at page 155 of that article. So basically what it is to say is this: I can build up to 1 hectare, and now I say to the state I want to build 10 hectares. And you may as well just grant it to me because there's already a 1 hectare facility on that site. That's what salami slicing is trying to avoid. But there's no suggestion in this case that the MEC granted the approval because my client had started the facility up to 1 hectare. What else the article says, also on page 155, is that it's acceptable to have salami slicing or splitting into stages where it does not try to reduce the importance of environmental impacts. And where we get back to on this is what the provision listed activity 28 actually allows. And listed activity 28 does allow you to do anything up to 1 hectare without prior approval. So my submission on listed activity 28 is this: whether we intended or not to enlarge it, we are comfortably within, or outside rather, listed activity 28. It's only if we don't get the approval and we say, who cares, we're going to do it anyway, that we would be acting unlawfully. It's a point that Justice Rogers made, that the argument that's been presented would be to say that you're precluding perfectly lawful behavior by interpreting commencement to include intentions. And I want to emphasize the point again about Section 24F. It's a criminal offense. So you're precluding lawful activities and actually criminalizing them based on that argument. And my submission is that that can't be right. Unless, of course, listing activity 28 is amended. My fourth topic is listed activity 8. And just a quick factual question, where is the abattoir? It's not on the same property. It's in the town of Robertson. And that's in the SAFAM founding affidavit. It's volume 4, page 292, paragraph 8. So what happens is the animals are slaughtered at the abattoir in the town, and then the waste is removed and taken to this facility. That's on this file. I think I pronounced this correctly. So in order for an activity to fall within activity 8, there have to be 2 requirements. There must be beneficiation as the first requirement, and your second requirement is that it must be of agricultural produce. It is not enough that, as a general matter, composting is beneficiation. And it is also not enough that composting or what goes into compost might be understood as agricultural produce. One has to look at what the listing notice defines these terms as, to understand it. So the definitions here, perhaps I can ask the court to go there. It's my heads of argument at page 21, paragraph 66. I just want to make sure the court is with me, aware of the time. So we know listed activity 8 says it's development and related operation of agri-industrial facilities. An agri-industrial is an undertaking involving the beneficiation of agricultural produce. But the definition of agriculture means feeding, breeding, keeping, or raising of livestock. It does not mean slaughtering of livestock, and it does not mean composting the waste that comes from a separate slaughtering facility of livestock. The question the court must ask itself is this: is composting slaughter waste from another facility the feeding, breeding, keeping, or raising of livestock? And the answer, as the High Court said, is no. And that really brings me to the end of that. There's a whole bunch of arguments about new reasons. So we've got some time left. So the argument was that, well, the MEC said that composting is benefication, and then elsewhere found that composting wasn't benefication. And that's really unfair. It's an unfair reading of what the MEC found. The MEC says it's in my heads at one stage that as a general matter, we understand composting to be beneficiation. But when the MEC is dealing with the question of whether it's beneficiation for purposes of listed activity 8, the MEC says composting does not fall within the ambit of beneficiation, basically for purposes of listed activity 8. And one doesn't read administrators' decisions as if they're a default thesis at a fancy university. An administrator has a lot of things to do, and they're not going to write perfect judgments as we might expect courts to do even. We should give them the benefit of the doubt and not attack them or try and point out contradictions which aren't there, in my submission. The other point is this: even if the MEC's reasons were different, the applicant asked Justice Nuku to declare that my client had started listed activity 28. So the judge had to decide the matter. And in this court, in the notice of motion, volume 13, page 1054, the applicant still seeks a declarator that my client has started listed activity 8. So this court gets the merits, as I submit it must. The court will have to decide that issue, notwithstanding what the MEC's reasons were. Briefly, there's a question of my client including listed activity 8 in the original application. Justice Nuku deals with this quite nicely. It's volume 11, page 932. And what he says, paragraph 97, it needs mentioning that when SAFAM submitted its application, it included listed activity 8. But as SAFAM and the trust, so all my clients correctly pointed out, this is on its own is not determinative of the question of whether listed activity 8 is applicable. Because whether it is applicable is a factual question. If the facts do not prove that listed activity 8 is applicable, that is the end of the inquiry. So the fact that I may have made a mistake and included it can't count against me now, which seems to be what the argument is. My last two topics are leave to appeal and costs. Leave to appeal, I'm just going to say, what do we do about the SCA, assuming the court agrees with Mr. Marcus? My submission would be to grant leave to appeal, to address the SCA's, and whether the court says the SCA should have decided all the issues, or whether the court says the SCA got it wrong in res judicata, to address the SCA, and perhaps even admonish it for not following this court's jurisprudence in Spillhouse and S versus Jordaan. And then the court should get into the merits, because as I've shown, the merits are so totally against the applicant with respect. But a lot of very clever, interesting arguments. But if one breaks it down, one sees why the activity that my client started doesn't fit within the listed notice. The last question is costs. So the SCA and the High Court both ordered costs against the applicant. The High Court said costs should follow the result. perhaps not the best judgment in this context on that, because you would think that the High Court would grapple with BioWatch and controversial sections of NEMA. But the SCA explained why it was ordering costs against the applicant. And that's basically because they litigate with a 200-page founding affidavit. They raise 1,000 issues, okay, I'm exaggerating now, most of which are abandoned. And they made quite serious allegations against officials, which are concerning. So the SCA's costs order, I would submit, there's no basis for this court to interfere with that discretion. What about this court? It's interesting. What does the court do? If the court only says the SCA should have decided everything, go back, perhaps in that instance I would say each party should pay its own costs. But if the court agrees with me, addresses the SCA, and ultimately finds against the applicant on the merits, then I would say that costs should follow the result. I've already made the point that the founding affidavit was very lengthy. Many issues have been abandoned. My clients have been put to great expense to defend the environmental authorization obtained. And what's very interesting is what the applicants say, or the applicant says in the written submissions. So the applicant says, if I lose, I should be protected by BioWatch. And then the next paragraph is, but if I win, SAFAM should pay my costs. But there's no explanation as to why there should be a distinction there. And perhaps the thought process is, well, we're both private parties, we're having a dispute about an authorization, and the ordinary rule should apply. And that would be my submission. Deputy Chief Justice, those are my submissions. I'm a little bit earlier than I expected to be. And I'll say again, I do want to assist the court on the res judicata issue, and I'm fully prepared to address that. I just didn't want to take up my half an hour dealing with it.
Thank you, Mr. Dubier. I think we'll take the tea adjournment, 15 minutes.
Okay, good day once more. Let's take our seats. Let us be ready. Thank you.
Oh. You argued by what?
I did.
Yes.
Richard Walsh.
How was that? He's a judge now, eh?
How was it? It was an ordeal.
Please rise for the Constitutional Court.
Questions?
Mr. De Beer, I hope I don't sound facetious, but I'm surprised by your lack of argument on res judicata. Must I take it as, well, let me not say anything.
I'm not going to concede it. I'm going to say what's in my heads of argument on it. I'm not going to assist the court. But from my client's perspective, what's critical here is the substantive issues, and that's why I argue those.
Well, you see, once a court rules matters res judicata and basically then doesn't decide the merits, effectively closing the doors on the litigant, the other litigant. So that is a fundamental right, as you yourself know. And so we must grapple with it, and it seems to me that there are a myriad of problems here. We judges here, that been and some still are in the High Court, we've made many settlement agreements, orders of court. Now, the settlement agreement tells you that the parties have agreed that the decision of the decision maker is set aside. What does that mean for that decision? What is the effect of it in law?
As Mr. Marcus said, when the court sets aside a decision, whether it's after a reasoned judgment or by agreement, it's a nullity. It never existed, and that decision is gone.
It never existed.
And again, the reason why I didn't argue it is because it's not the strongest point, in my view. I mean, I'll be candid with that. The reason why I didn't argue it or deal with my address is because it isn't the strongest point. And the problem, as I see it, is what the...
Sorry.
Apologies, my voice is quite loud, so let me move the mic a bit closer. Jasmine, the concern that the applicants raise, and I think it's a valid concern, is that many decisions are set aside, whether by agreement or not, and the matter is remitted. And to say that because there happens to be a first order that may have dealt with a similar issue, no one is allowed to attack the second decision, it's a concern. It doesn't sit right. It's counterintuitive, and it's a problem. Of course, here was one issue which is the same. Did you start listed activity 28? That's the sort of reasoning that was put up, and those are the submissions I made in the heads of argument. But as Mr. Marcus said quite correctly, listed activity 8, that issue was never before Hlophe JP, whether it was settled or not. So how that can be res judicata, it's difficult.
But just on Civil Procedure 101 and on Admin Law 101, once the decision is agreed to be set aside, there's nothing. And so secondly, what does remittal mean? It says remit for a fresh decision. What does that mean?
It says do it again.
Exactly. And does it mean you can't, it's insulated from review?
Well, again, I understand the logic of the SCA to be, in this case, it was the same issue. Was the facility bigger than a hectare or not? And really, court should be dealing with that. But if one takes that principle further than this case, and again, this case has other problems as well, there's a concern, because also then you insulate public power from scrutiny by the courts, which nobody wants, I would say.
said, with the greatest of respect, you talk about logic. I don't see any logic here, but let's just talk about law. We agree now that the first decision is a nullity, by order of court, mind you, not what the parties say, by order of court. And secondly, we agree now that the decision maker must take a fresh decision which is susceptible to review. Now, let's take the applicant's position here. How is this order binding on the applicant? He is expected, according to the SCA, to go and apply for a rescission. How does he do that? How does he go to the court and say, listen, in terms of Rule 42(1)(a) or the common law, I'm a party to this, or I'm a party affected by this decision? How does he do that?
What he would have done is to say this, hypothetically, if he needed to say, I should have been joined. I was a necessary party because it affects my interests, because it's precluding me from challenging the remitted decision. I was not joined. I intervene in the matter on that basis, and I say to the High Court, rescind the order on the basis of a material non-joinder and deal with it again.
Why should he do that? Why should he run up that cost? He looks at this order and says, well, you guys go ahead.
Well, yeah, I mean,
JP said what you must do, so let's see what happens.
The position taken in the founding affidavit was this: that's in the past. We now have a fresh decision. Why am I going to challenge that order where I wasn't even part of that case? I don't need to, because it doesn't stop me from questioning the second decision.
Well, I think I'll leave res judicata there for now. Did the SCA seek to develop the common law here? Is that your argument, or are you?
Well, I mean, it's not my argument. I think it's probably more again, I'm almost conceding now, a misapplication of a settled test. But the one trick in that is that res judicata and issue estoppel, the relaxed version, the one requirement is always same parties. Right, and we know it's not same parties here. Having said that, in public law, it's a bit tricky. I think Justice Tsikri, I hope I pronounced that correctly, made the point that there's so many reviews and there might be many people affected by it, and how do you know who to cite and who to join? And their orders in rem. But
that is not the SCA's ratio decadenti. It doesn't say in its reasoning that it's relaxing this rule or relaxing.
No, it doesn't. It just basically says it's the same issue before Hlophe JP and before us, and because Hlophe JP finally determined it in the settlement order, that's the end of the story. That's the reasoning.
Okay, thank you. Let me go to remittal, which is arguably, but no higher than that, a more difficult question. The argument that you've presented here today regarding listed activities 8 and 28, as opposed to that Mr. Marcus presented earlier, strongly demonstrates to me, and please disavow me from that if I'm wrong, that there are strong factual issues here that need to be carefully considered before we venture into the terrain of saying, well, we can decide this case. Now, once you've answered that question, I'd like us to have a look at spillovers very closely.
Justice Majid, as I see it, really the factual question here is the size of the facility. It seems to be that we all agree it's less than a hectare now.
Stop you there. Are you then not quibbling with the question whether these are agricultural byproducts?
No. Sorry, factual question. So the question of fact is how big is the facility? But then the question is, well, we know what's happening. The facts are there is waste coming from an abattoir and it's being composted there. And the question is, how do you apply the listed activities to those facts? So as I see it, there aren't really factual disputes in that sense. It's more of a question of application, interpretation of the listed activities, and then the application of them to those facts. And Justice Majid, what I will say is this: I know there's no SCA judgment on this, but there is a High Court judgment. And I don't think Justice Nuku's judgment, it's not short. He grapples with the issues, he summarizes the arguments, he does the work of a judge, if I can say that respectfully, Justice Nuku does. So it's not a situation where, we're coming to the court and the High Court and the SCA have decided this on a technical basis, and now we're saying, all of you, please trawl through this massive record to find the factual disputes, and then to, as a court of first instance, determine important questions about the interpretation of NEMA listing notices. The court has a judgment before it with factual findings. And as I understood the argument, we aren't debating the main pure factual question about the size of the facility.
The reason why there's a hierarchy and a Supreme Court of Appeal, this court prefers reasoned judgments from all the courts that have gone before. But let's go to Spillhouse. We know that in Spillhouse, the problem was that the SCA didn't decide the mandatory interdict question. And then the court, considering this point, says the following at paragraph 49, this court: it is common cause, a very important differential. It is common cause that the relevant zoning scheme was not followed. And the applicants in whose interest the zoning scheme was passed have the right to enforce it. And then the court says it is this right which underpins the relief sought. So it says then in matters like this, it is not necessary for the applicants to show that they've suffered special damages and that flows. And then says, therefore, where there has been non-compliance with the zoning scheme, interdictory relief sought is usually granted. So there was no real dispute before the court. And that is why the court said, well, the whole case is before us, there's no issue really, and so we decide the merits. It's very different here, isn't it?
Yes. Perhaps, but there might be another way of looking at it, Justice Sajid, which is this. The court might take the view that what it's really concerned about is the SCA's finding on res judicata. And it might say that's a significant constitutional issue that the court should determine within its jurisdiction. And then the court might say, on the question of the listed activity 28 and 8, whether they started or not, there is a reasoned high court judgment. That's not something that the court, within the interest of justice, has to grant leave to appeal on. Now, granted, there's two counterpoints. One, I'm not sure whether the court can grant leave on certain issues and not others. And the other point, and I think Justice Majid, you made it already, apologies if it wasn't you, what about the rights of the applicant to have their dispute resolved, including on an appeal matter? So those would be the difficulties there. On the other hand, we have a reasoned judgment, we have a full record, we have full argument written in our oral submissions. And the court is in a position to decide the merits, would be my submission. The other thing from my client's perspective, and I think from the applicant's perspective, is finality is also important in litigation. And there is some virtue in that as well that should factor into it.
Yeah, and then just lastly, if we do remit, I suppose there's no quibble about whether the same panel, those who are still there, should hear it in the SCA.
We're not in a Makate realm. They also didn't decide the issue, which is really what happened in Makate, the substantive issues. Perhaps, but the court can also say that the president of the SCA can exercise a choice there, and that will be up to her.
Yes, thank you. Thank you, DCJ.
Okay, I think that seems to be it for you.
Thank you, Deputy Chief Justice.
Thank you. Mr. Marcus?
Deputy Chief Justice, with your leave, my learned friend, Mr. Scott, will do the reply.
Thank you, Chief Justice, members of the court. I suppose we just point out at the outset that my learned friend initially said he didn't attempt to start with res judicata because it wasn't his strongest point. He was happy to take questions on it. When he was quizzed on it, the high watermark, as I understood it, was that he concedes there's a concerning finding by the SCA judgment. If that is so with respect, then we respectfully submit that the appeal should succeed, at least on that basis. Now, the point to make there is that SAFAM's heads stridently oppose and say all of the issues were covered by the Schlorped JP order and therefore were foreclosed by res judicata. He's entirely conceded that on his feet. He says only the one issue of 28 was dealt with. Let me then turn to listed activity 8. Now, of course, what was before the High Court and what was before the SCA it must be remembered that that was a review of the MEC's appeal decision. And the MEC dismissed the internal appeal, and the court will find this at volume 7, page 592 to 593, and it's para 6.1.8. And the MEC said, composting does not fall within the ambit of beneficiation, and thus listed activity 8 is not triggered. So the point was made that composting wasn't beneficiation, and we set this out in further detail in the heads of argument. But the reasoning was inconsistent, and if one looks elsewhere, and this is the definition that we understand is accepted by learned friends, is that composting is a common practice associated with agricultural practices and prevents organic waste from going to a landfill. It's a means, therefore, of beneficiation and treating a waste stream that could otherwise have detrimental impacts on the environment. Now, that is also from the MEC's appeal decision, and the court will find that at para 6.1.5. That's 6.1.5, volume 7, page 590. Now, what the High Court did in a review is it essentially found on a different basis that the MEC was correct. And my learned friend goes into the ex post facto reasons, points, and various arguments. We submit that if the court looks at the MEC's reasoning, it's internally inconsistent. Now, once that is so, in a review, as this court knows, the question isn't, was the outcome correct? The question is, was the process by which that decision was taken correct? And my learned friend says, well, we must just read the judgment. We shouldn't hold an administrator to the standards of a court judgment. But with respect, he is mistaken, because there is a bit of an oddity, but it is the law, that what happens in an appeal before a court is that the court can agree with the decision of the court below for different reasons. It's a question about whether the outcome was correct. In a review, the very question is whether the reasons were correct, whether the process that was followed was correct, regardless of whether the correct outcome was reached. In other words, we submit that once the High Court found on a different basis, it should at that stage have upheld the review, and then it would have been remitted back. And my learned friend tries to save the day by relying on the declaratory relief. But the declaratory relief is separate from the review relief. In other words, the court might find that the interpretation was, by the High Court, the interpretation, it might have been that listed activity 8 didn't apply, but that wouldn't cure the review problem, because in the review, the question is, did the decision maker follow the correct process and the reasoning process? And in other words, it should have been remitted back at that stage. But what Mr. Marcus has dealt with in detail, and I shan't traverse all of it, is really this idea that, as we see it, everybody agrees that composting is beneficiation, and composting typically is where one takes a waste source and turns that into compost, which is then a product that can be sold. So the narrow question is whether the waste from the abattoir amounts to agricultural produce. Now, of course, waste is in the eye of the beholder. Agricultural produce doesn't mean that products that are fit for sale would be composted, because that would never be the case with respect. So in other words, if a farmer is selling eggs, he's not going to put the good eggs that he sells into the compost heap. Similarly, SAFAM is in the business of selling meat. They're not going to put the meat that is fit for sale in the compost heap. By definition, one has to read agricultural produce broadly, because otherwise composting would never fall within listed activity 8. And the point here is that SAFAM itself explains, and Mr. Marcus gave the court the reference. This is at volume 8, page 725, paragraph 15.3. So volume 8, page 725, paragraph 15.3. And these are SAFAM's words. What SAFAM says is that in this context, the waste from the abattoir isn't really waste at all, because it is an input in the compost process. And what Mr. Marcus has already pointed out, and they describe the various things that go into the compost. One of them is animal carcasses. In other words, the very thing they sell. It's exactly the same, and we submit that a broad definition of agricultural produce has to be taken into consideration. Otherwise, composting, which is a generic and usual method, won't fall within listed activity 8. And as the court will see, and Justice Majid has highlighted the various, factual points. And in a sense, composting can't just take place. There's, various temperatures that need to be satisfied, a whole range of steps that need to be taken. And the point is that that should be done after they've been investigated, after there's been an environmental authorization process. And just on Justice Rogers' point about the proposal, and we just wanted to emphasize that, and the court will find this at volume 3, page 268, about what SAFAM's proposal was. In other words, was it just the compost facility? It was broader than that. So if the court makes a note, volume 3, page 268, and this is the department, it had just received SAFAM's proposal, and the department describes it. The department notes that the proposal entails the establishment of a compost facility to recycle and treat abattoir and organic waste over an area of approximately 3.6 hectares. The proposal also includes the development of a feedlot for the keeping of animals for commercial production on approximately 6,000 meters squared. And that also makes sense with respect, because it's not the case that the animals come in and there's some sort of conveyor belt and they are, abattoired and carved up immediately. The animals need to remain, and then there is a process by which they are dealt with accordingly, and then there is waste from the animals, both that are kept on the premises as well as the ones that are carved up. And there are two ways. The one is that animals who die of natural causes can't, by law, be used in the abattoir. In other words, it can't be sold unless they're slaughtered for that purpose. But those animals and their waste, their bodies, which is exactly the same product that is being sold in the butchery, that is what is going into the compost heap. That is agricultural produce on our submission. Then let me deal finally with the topic of I beg your pardon. There's a further point to be made, is that my learned friend has conflated the listing activities 28 and 8 in respect of the footprint, because 28 says that there's a threshold of 1 hectare, but that is not so for listed activity 8. 1 hectare is 10,000 square meters, and listed activity 8 limits it to 2,000 meters squared. So the point is that if we are right on the interpretation of listed activity 8, then SAFAM is out of the threshold by a long way. Deputy Chief Justice.
Thank you, Mr. Scott. Questions? Okay. Thank you, Mr. Scott. Thank you.
Thank you, Deputy Chief Justice.
Judgment is reserved. Court adjourns.